Got their legal warriors. I've got another question from a viewer. They wanted to know, will prosecutors be able to see their texts and emails in a criminal case? Well, if you want the answer to that question, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years. I'm putting out these videos to help educate the public. So if you find it useful, please like and please subscribe. More people get to see it, more people get the help they need. And I'm just going to jump right into it. What are situations where we care about if prosecutors can see our emails or our texts? Well, the first one that jumps out in my head would be order violations. No contact order, protection order violations, and this happens all the time. In a criminal case, let's say it's a DV type case, almost always the court is going to issue a no contact order at arraignment or at initial appearance in front of the judge. And as you might guess, many times, most of the time even, the alleged victim in these cases still wants to have contact with the suspect, with the defendant. In fact, they often reach out to the defendant. They actually text them or email them or call them. And then what does the person do who's the defendant? Well, they're sort of between a rock and a hard place. Do they not answer and don't pay attention, let's say, to their family or their kids? They're curious. Do they not answer and risk upsetting the person that they probably care about and wonders why they're not being talked to? Or do they answer and risk the prosecutor finding out about that text or email, now getting rearrested and subject to even more criminal charges? So can the prosecutor figure it out? The answer is typically only if the alleged victim in this hypothetical tells the prosecutor or someone else tells the prosecutor. Of course, the law school answer is, well, law enforcement could get a search warrant if they believe that a crime has occurred, violation of the order, but they need evidence. They just can't do it willy-nilly. They don't have a right just to go on your phone. They hear tell that the defendant's been texting the victim and the victim's not cooperative in this law school thing. What could the cops do? Well, the cops could apply for a search warrant. Dear judge, I believe for these reasons there's going to be evidence of the crime, a violation of a no contact order on the defendant's phone. Please authorize that I seize the defendant's phone and search it within the next 10 days. Good law school exam, but I've never seen that in real life in 25 years. Of defense work, 7 years of prosecution. Man, I'm getting old before that. But so usually what will happen is, if how they get to see it is that alleged victim or somebody gets mad. I don't like the answers you're telling me, or I really think that you're an abuser, or I want you to pay this bill, and if you don't, I'm going to give it to the prosecutor, or there's another fight. People shouldn't be doing this, but they do. And then they give it to the prosecutor, then we got big problems, because now we see a whole bunch of more charges that can show up and leverage over the defendant. And there are certain jurisdictions that shall remain nameless that if you dare set a case for trial, they start to go straight to the victim. They start to pressure the victim. Hey, have they been texting or emailing you? As long as they'll trick that person into sharing that information. And now they leverage the possible new charges and trying to force a plea on the original charge. So it puts you in a really bad shape. So we really don't want to do this, because while the prosecutor is typically not going to get that information without something else happening, if they do, it's really damaging. So, Lance, why doesn't the prosecutor just go get the information? Why don't they just look for it all the time? Shouldn't I be worried about that? Well, typically not, because remember, the prosecutor has a very hard job. They have hundreds, if not thousands, of cases, and they can only spend so much executive function, mental energy, and emotional energy towards any particular case. They're not out there trying to track this stuff down the same way for the police, right? There's too much going on, and that's why in a good number of cases, there's countless amounts of communication going back and forth between people when there's a no contact order, and almost always nothing comes of it, because the system's just not designed to catch up to it. And we do have rights to privacy. There would need to be some type of indication of violation before someone will get a search warrant. The judge can't order you to turn over all this stuff, or at least I've never seen it, and they shouldn't, and we would challenge that. And so your stuff is going to remain private unless it gets out. So can the prosecutor see it? No, unless someone gives it to him, or unless we get this weird situation where law enforcement gets a search warrant to try and find it. And the corollary to that is, hey, are people following me around to see if I'm violating a no contact order? No, they're not, right? They're just not. I can think of a handful of cases where you get a very interested officer who has a crush on the alleged victim, and therefore they're going to check up, be the big hero to this alleged victim, and they're going to, make sure the bad guy is caught. But that's one in a 10,000 case, not a typical one. So I'm not telling anyone to violate the rules. What I am trying to say, I'm trying to answer the question is they're only going to get the information if someone gives it to them. So beware if you're texting and emailing something you're afraid about the prosecutor seeing. Think about who you're sending it to. Because if they see it, they will use it against you, and it could make your attorney's job a whole lot harder. So I hope you found that useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. Just as important, if you have a criminal matter in Washington State and you need some help, feel free to reach out to our firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.